A stranger sent Megan a Facebook message on a Tuesday morning in March 2023. The message was 4 sentences long. It said, "My name is Priya. I think we may know the same man. I think our daughters are sisters. Please call me." Megan read it 3 times. She had 2 daughters. Her youngest, Grace, was 4 years old. She had never met anyone named Priya. She had never heard the name Priya Sharma in her entire life. She almost deleted it. But something made her click on the attached photo. The little girl in the photo had her husband's eyes, his exact jaw, his exact forehead, the shape of the mouth, the particular way the ears sat on the head. Megan sat in her kitchen in Columbus, Ohio for 45 minutes and could not stand up. Her husband Daniel was in Cincinnati for work. He was always somewhere for work. In 11 years of marriage, 11 years, she had never once questioned that. She was about to question everything. Megan Torres grew up in Dayton, Ohio, second of 3 siblings, studied nursing at Ohio State, graduated in 2007, got her nurse practitioner certification in 2010. She was practical, grounded, and not someone who dramatized things. Her sister described her as the most competent person in any room. She was the one who showed up when there was a problem. She was the one who figured things out. She met Daniel Torres at a mutual friend's birthday gathering in Columbus in 2011. He was charming and funny and ambitious. He sold pharmaceutical equipment for a mid-size regional supplier out of Indianapolis. He wore good shoes. He had a warm handshake and remembered details. He called her 3 days later. He remembered her birthday twice before she agreed to a second date. They dated for 18 months. They got engaged on a weekend trip to Savannah. They married in June 2013 at a vineyard outside of Columbus. There were 112 guests. Her parents danced. His parents danced. Everyone said it was the kind of wedding that felt real. By 2016, they had their first daughter, Lily. By 2019, they had their second daughter, Grace. During those years, Daniel's career accelerated steadily. He was promoted to regional sales director in 2018. His territory expanded to cover a 7-state Midwest corridor: Ohio, Indiana, Illinois, Michigan, Wisconsin, Minnesota, and Iowa. He was traveling 3 weeks out of 4 by 2020. He said it was the nature of the industry. Regional directors traveled. It came with the title. He apologized about it often. Megan had reduced her clinical hours when Lily was born and reduced them further when Grace arrived. She was working 2 days a week at a family medicine practice in Westerville. She managed the house, the kids, the school pickups, the pediatrician appointments, the grocery runs, the birthday parties, the permission slips, the holiday cards. She didn't love the arrangement, but she trusted him. She trusted that the traveling was real. She trusted that the late-night texts about delayed flights were real. She trusted that the job was what he said it was. They had a joint checking account and a joint savings account with approximately $40,000 in it. They had a mortgage on a 4-bedroom colonial in Clintonville, 2 car payments, a 401k each, the ordinary architecture of a shared life. On paper, they looked exactly like what they were supposed to be. Here is what Megan did not know. Daniel had been renting a 1-bedroom apartment in Chicago's River North neighborhood since January 2020. The monthly rent was $1,800. He was paying it from a Chase account she had never seen and never knew existed. The woman who lived in that apartment was named Priya Sharma. She was 34 years old, an events coordinator based in Chicago. She had a daughter named Maya, born in August 2021. Maya was 3 years old when she took her first DNA test. Stay with me, because what happened next is the kind of thing you think only exists in cable documentaries. Priya Sharma had purchased an Ancestry DNA kit for her daughter Maya as part of a family history project. She wanted Maya to understand her ethnic background on both sides. Her own family was Indian American, originally from Hyderabad. Maya's father, the man Priya knew as Dan, had told her his family was Mexican American and Italian on his father's side. Dan had also told Priya, when they first started seeing each other in late 2019, that he was divorced, that his marriage had ended 2 years earlier, that he had no children, that he traveled constantly because he worked as an independent logistics consultant. Priya believed him. She had no reason not to. She had been with Dan for 4 years by the time Maya's DNA results came back. He came to Chicago 2 or 3 times a month, sometimes more. He paid for the apartment. She had assumed the lease was in his name and never looked closely. He brought groceries. He knew her friends. He showed up for Maya's birth. He held the baby. He cried. He had been present, attentive, and emotionally available in the way that people sometimes are when a relationship exists only in compartments, when there is no ordinary friction, no bills to argue about, no history to navigate, no shared exhaustion from the everyday. Their time together was always a visit, always temporary, always curated. Priya thought she was in a long-distance relationship with a divorced man who was slowly working toward relocating to Chicago. She was patient. She was building something. She thought they were building it together. Maya's DNA results came back on a Monday in March 2023. The results flagged a 1,750 centimorgan match. In genetic genealogy, a match at that level indicates a half-sibling relationship. The platform displayed the match prominently at the top of Maya's results page, a child named Lily Torres, age 7, located in Columbus, Ohio. Lily's DNA profile had been created by her maternal grandmother, Megan's mother, as part of a family reunion heritage project 2 years earlier. She had uploaded it to Ancestry to find distant cousins. She had found something else entirely. Priya stared at the results for a long time. She searched the name Lily Torres. She found a birthday post on a private Facebook page belonging to someone named Megan Torres, Columbus, Ohio. She looked at the family photo in the profile picture. It was a Christmas photo, dated December 2022, a family of 4 in matching pajamas, 2 little girls, a woman, and Dan. He was smiling in the photo. He was holding the smaller girl. He was wearing the same watch he had given Priya on his birthday 6 months earlier. Priya sent the message that Tuesday morning, but it gets worse. When Megan eventually hired a private investigator and authorized a deeper background check on Daniel, the PI uncovered something neither woman had known. Between 2017 and 2019, before Priya, while Lily was still a toddler, Daniel had maintained a separate relationship with a woman in Indianapolis. He had met her through work. That relationship had ended in late 2019, apparently because she had grown serious about wanting to get married, and Daniel had not been able to sustain the lie in that direction. He had moved on to Priya 4 months later. Daniel Torres had been living in parallel for most of his marriage. Not one affair. A sequence. A system. Megan did not confront Daniel immediately. She is the kind of person who needs to understand before she acts. She needed to know the shape of the thing before she could name it. She needed the facts arranged in front of her before she would trust herself to speak. She called her sister that afternoon and said nothing about Daniel. She just asked if she could bring the kids over for a sleepover. Her sister said of course. She packed an overnight bag for each girl. She drove them over. She hugged them at the door and came back home and sat at the kitchen table. Then she drove to a FedEx office and printed the Facebook message Priya had sent. She printed Priya's profile photo. She printed the screenshot of the Ancestry DNA match report that Priya had included in a follow-up message. She put the pages in a manila envelope. Then she called a family law attorney named Rebecca Walsh. Walsh had been practicing divorce and family law in Franklin County, Ohio, for 19 years. She was not the kind of attorney who counseled emotional processing. She was the kind of attorney who asked what documents you had already touched and whether anyone else knew. She told Megan 3 things in the first call. 1. Do not move money. Do not close accounts. Do not do anything that looks retaliatory or that could be characterized as your own dissipation. 2. Keep a written log of everything Daniel tells you about his whereabouts from this point forward. Date, time, what he said, word for word. 3. Order the DNA test for Grace. If Maya is Daniel's child, you need the paper record establishing the relationship now, not later. Megan ordered a second Ancestry DNA kit that night. She also bought a separate DNA paternity test kit that could be processed on an expedited basis. She also, on her own initiative, opened a new incognito browser window. She typed in Daniel's name and the word Chicago. She found a LinkedIn page endorsement. A woman named Priya Sharma had endorsed Daniel Torres for sales strategy in September 2021. Maya had been born 1 month earlier. Megan printed that too. She then went back through 2 full years of joint bank statements, account by account. She was looking for payments that could be rent on an apartment, regular transfers, monthly patterns. She found nothing that matched. No recurring Chicago payments, no $1,800 transfers, nothing that looked like a second household. That absence told her everything. The money for the Chicago apartment wasn't coming from their shared accounts. That meant Daniel had money she didn't know about, a source she didn't know about, an account she didn't know about. He hadn't just hidden a relationship. He had built a parallel financial life to sustain it. Stay with me. 2 weeks after Priya's message, Grace's expedited DNA results came back. They confirmed a half-sibling match between Grace Torres and Maya Sharma at a probability exceeding 99.97%. Megan scheduled a meeting with Rebecca Walsh the next morning. The following Friday evening, after the kids were in bed at her sister's house, Megan told Daniel she wanted a divorce. She had spent the preceding week quietly moving critical documents, passports, birth certificates, insurance cards, her own financial records, to her sister's home. She had opened a separate checking account in her name alone and transferred the last 2 months of her own paychecks into it, which Walsh had told her was legally permissible to protect her own earned income. She sat across the dining room table from him and said the words. Daniel's first response was not to deny the affair. His first response was not to apologize. His first response was, "How did you find out?" He sat across from her for 40 minutes and tried, methodically, to determine how much she knew. He asked her who she had spoken to. He asked her whether she had talked to anyone at his work. He asked whether she had spoken to a lawyer yet. He asked about the kids. He asked whether she was planning to take them somewhere. He did not once, in 40 minutes, say he was sorry. Rebecca Walsh filed for divorce in Franklin County Common Pleas Court in April 2023. The petition included a claim for dissipation of marital assets. In Ohio family law, dissipation is defined as one spouse's use of marital property for a purpose unrelated to the marriage during a period when the marriage is undergoing an irretrievable breakdown. The legal doctrine exists because courts recognize that infidelity is not just an emotional harm, it is frequently a financial one. Walsh subpoenaed Daniel's financial records, all of them. Every bank account, credit card statement, business filing, tax return, and brokerage account associated with his name or social security number for the previous 5 years. What the forensic accountant found took 3 weeks to reconstruct. Daniel had opened a Chase business checking account in early 2019 under a sole proprietorship he had registered in Illinois called TD Consulting Services. He had never disclosed this entity to Megan. He had never mentioned it in any of their joint tax filings. The business had no real clients and no real operations. It existed as a vessel. He had been diverting a portion of his commission income into this account for nearly 4 years. He had done this by requesting that his employer split his commission disbursements between 2 accounts, his standard direct deposit into the joint checking account and a secondary deposit into TD Consulting Services. His employer's payroll department had processed the request without question. This was not unusual. Sales reps sometimes split deposits for business expense management purposes. From TD Consulting Services, over 48 consecutive months, Daniel had transferred a total of $91,240. The forensic accountant reconstructed the spending in granular detail. $21,300 had gone to rent payments on the River North apartment, paid to a property management company in 12-month increments. $14,200 had gone to what the accountant categorized as child-related expenditures, a pediatrician in Lincoln Park, a child care co-op in Wicker Park, a car seat purchased at a Target on North Clybourne, a double stroller, clothing from a children's boutique on Armitage Avenue. $18,600 had gone to restaurants, hotels, and transportation expenses within Illinois and Indiana. dates, weekend stays, and at least 7 round trips on Amtrak between Columbus and Chicago that Daniel had told Megan were regional sales calls. $11,400 had gone to gifts, jewelry from a boutique in the Mag Mile, electronics, an Apple Watch, a cashmere coat. The remaining $26,740 had been distributed as cash ATM withdrawals, peer-to-peer Venmo transactions to recipients listed under initials, and 3 wire transfers to an account the forensic accountant was initially unable to identify. One of those wire transfers, when eventually traced, turned out to be a deposit on a vacation rental in Door County, Wisconsin, a long weekend trip taken in July 2022. Megan had been in Dayton that same weekend attending her cousin's bridal shower. None of this money had appeared in the couple's joint tax returns. Some of it had been further obscured by Daniel's practice of submitting Chicago hotel and restaurant receipts to his employer as business expense reimbursements. He had been double-dipping. Getting reimbursed by his company for personal expenses, he was simultaneously categorizing as business costs. When the forensic accountant's report was shared with Daniel's employer as part of the discovery process, the company opened its own internal audit. Within 60 days, they terminated Daniel's employment. He was denied severance. He was not eligible for unemployment because the termination was for cause. Daniel's attorney attempted to get the employer records excluded from the divorce proceedings on the grounds that they constituted prejudicial employment matters irrelevant to the marital estate. Judge Sandra Whitmore denied that motion. But it gets worse. During the discovery phase, Walsh's legal team subpoenaed Daniel's personal cell phone records through his carrier. The records showed 4,219 text messages between Daniel's phone number and Priya Sharma's phone number between January 2020 and March 2023. This did not include messages sent over WhatsApp or iMessage that were end-to-end encrypted and could not be subpoenaed from the carrier directly. In the text message records that were recoverable, Daniel had explicitly discussed concealing his marriage from Priya on multiple occasions. In an exchange from September 2021, exactly 1 month after Maya was born, Priya had asked Daniel when he was planning to move to Chicago permanently. Daniel's response, verbatim in the subpoenaed records, "Soon. I just need to tie up some loose ends in Columbus." Megan was the loose end. The private investigator's surveillance report was entered as a court exhibit. It included time-stamped photographs of Daniel entering and exiting the River North apartment building on 17 separate occasions between November 2022 and March 2023, during periods when Daniel had told Megan he was in Indianapolis, Louisville, or Cincinnati for work. It included a photograph of Daniel pushing a stroller in Lincoln Park in January 2023. It included receipts from a restaurant on North Wells Street dated December 23, 2022. Megan had spent December 23rd alone in their Clintonville house, wrapping Christmas presents, because Daniel was in Cincinnati for work. If you are watching this and you are wondering what legal protections actually exist for someone in Megan's position, here is what you need to understand. This matters whether you are currently in this situation or you are watching to make sure you never end up there. In Ohio, and in most equitable distribution states across the United States, dissipation of marital assets is a recognized legal doctrine with real financial teeth. It applies when one spouse deliberately wastes, conceals, or destroys marital money for purposes that benefit only themselves, particularly in the context of an affair or other marital misconduct. Courts look at 3 primary factors when evaluating a dissipation claim. First, timing. When did the dissipation begin in relation to the marital breakdown? Daniel began diverting funds in early 2019. He and Megan were not experiencing any documented marital problems at that time. However, Ohio courts apply a 5-year look-back period for dissipation claims, and the court found that Daniel's double life and the secret it required sustaining constituted an ongoing breakdown of the marital relationship from the moment the Chicago apartment was rented. Second, purpose. Was the money spent on something that produced a marital benefit? Paying rent on a secret apartment for a secret girlfriend who was raising a secret child is not a marital benefit. This is not a close call. Third, concealment. Did the spouse actively hide the spending, or was it impulsive spending that happened to benefit someone outside the marriage? Daniel used a separately registered business entity with a fictitious name. He falsified employer expense reimbursements. He split his payroll deposits across accounts without Megan's knowledge. He filed joint tax returns that omitted the TD Consulting Services income entirely. This was not careless. This was architecture. When a court finds dissipation, the standard remedy is to credit the non-dissipating spouse. The total marital estate is reconstructed as if the dissipated money had never been spent. The full $91,240 is added back into the estate calculation. Then the estate is divided from that corrected total. This means Megan was not simply seeking half of what was left. She was seeking half of what should have been there, and receiving additional advantage because the dissipation itself was counted against Daniel's share. There is also the question of economic fault. Ohio is a no-fault divorce state, meaning you do not need to prove misconduct to dissolve a marriage. But courts are explicitly permitted to consider economic fault, measurable financial harm caused by one spouse's conduct, when determining how to divide assets. The concealment, the false business entity, the tax fraud, the employer fraud, all of it fell under the umbrella of economic fault and was weighed against Daniel in the asset division. If you are currently navigating relationship betrayal of this kind, whether the discovery is recent or still unfolding, BetterHelp connects you with licensed therapists who specialize in exactly this category of trauma. Betrayal recovery, financial trauma, and relationship forensics are distinct clinical areas, and finding a therapist with experience in these areas matters. The link is in the description at betterhelp.com/betrayed. Walsh also moved on Daniel's business expense fraud as a separate ground for increasing Megan's share of the marital estate. The argument, by submitting personal expenses to his employer as business reimbursements, Daniel had inflated his business expense reimbursements and suppressed the household income that should have been flowing into the marital estate. The court agreed to factor this into the overall asset calculation as additional economic fault. Meanwhile, Priya Sharma was not a party to the Ohio divorce proceedings. She had been voluntarily cooperative with Walsh's investigators from the beginning, because she too had been deceived, and she understood that cooperation served her interests as well. She was simultaneously pursuing a paternity establishment action in Cook County, Illinois, to ensure that Daniel was formally recognized as Maya's legal father and obligated to pay child support. That action was resolved by default when Daniel declined to contest paternity after the DNA results were formally entered into the Illinois record. He would eventually be ordered to pay child support in 2 states. The divorce trial in Franklin County was scheduled for September 2023. In the 5 months between the filing and the trial date, Daniel's attorney made 3 separate settlement offers. The first offer proposed splitting the marital estate equally with no dissipation credit and a shared custody arrangement. Walsh declined to engage with it. The second offer proposed acknowledging a portion of the dissipation, approximately $40,000, while contesting the remainder and requesting a 50-50 custody split. Walsh declined. The third offer, made 6 weeks before trial, proposed an asset division that gave Megan roughly 55% of the estate and primary custody, with generous parenting time for Daniel. Megan rejected it. She had reviewed the forensic accountant's report. She knew exactly what she was owed. The trial proceeded in September. Daniel's attorney made one substantive argument worth noting, that the $91,000 dissipation figure should be partially offset because a portion of the funds had been spent on Maya, Daniel's biological child, and that child support obligations would have existed regardless. The argument was that some portion of the spending was not dissipation, but a parental obligation that simply hadn't been disclosed. Judge Sandra Whitmore rejected this argument in full. Her reasoning was direct. Daniel had not disclosed Maya's existence. He had not voluntarily established paternity. He had not sought any legal framework for contributing to Maya's care. He had constructed a fraudulent financial infrastructure and operated it covertly for 4 years. The question before the court was not whether Maya deserved financial support. She did, and that was being addressed separately in Illinois. The question was whether Daniel's covert spending from marital assets constituted dissipation. It did. The manner of the spending, secret, fraudulent, sustained, was the determining factor. Judge Whitmore found dissipation of marital assets in the full amount of $91,240. She applied the full dissipation credit. The marital estate, the house in Clintonville, both retirement accounts, the joint investment account, and 2 vehicles, was valued at $480,000. With the dissipation credit applied, the effective total was $571,240. Megan received approximately 59% of that restored figure, which translated to assets worth $286,000. Daniel received the remainder. Megan was awarded the house. She refinanced the mortgage in her name and used a portion of the retirement account offset to cover Daniel's equity interest. She did not have to sell. She did not have to move her daughters. On custody, Judge Whitmore awarded Megan primary residential custody of Lily and Grace, with Daniel receiving alternating weekend parenting time and 2 weeks in the summer. The custody arrangement was shaped in part by Daniel's behavior during the proceedings themselves. His attorney had advised him repeatedly not to lie under oath during his deposition. He did anyway. When confronted directly with the subpoenaed text message records, specifically the September 2021 exchange about tying up loose ends in Columbus, Daniel testified that he did not recall sending those messages and that the records might reflect a typo in the phone number. The phone number was his. The same number had been active and in Megan's contacts for 11 years. Judge Whitmore's written opinion included a passage noting that Daniel had demonstrated a consistent pattern of deliberate misrepresentation, including misrepresentation offered under oath, and that this pattern was a relevant factor in the court's assessment of his credibility and judgment as a co-parent. Daniel was also ordered to pay 60% of Megan's attorney and forensic accounting fees. The combined total was approximately $31,000, 60% of which came to $18,600 owed by Daniel. His job was gone. His Chicago apartment was gone. His marriage was gone. His reputation in the Columbus area professional community was substantially gone. Walsh's court filings were public record, and the forensic accountant's report summary had been mentioned in a legal industry newsletter. Daniel left Ohio in November 2023. He relocated to Indianapolis. No one who knew him well was surprised by that choice. But here's what they didn't know yet. When the story attracted attention through a Franklin County legal blog that covered notable family court decisions, the Indianapolis Woman, the one from the 2017 to 2019 relationship, reached out to Megan's attorney through a mutual contact. She had documentation, a paper trail of her own receipts, text message records, a timeline. She was consulting with an attorney in Indiana about her options. What she did with that documentation remains, as of this recording, unresolved. So what do we actually make of Daniel Torres? He did not have a moment of weakness. He did not fall into something and find himself unable to get out. He built a structure